Hi guys! Welcome to another episode of Attorney Vlogger, Law for the Everyday Layman. Today we continue with our discussion on the Revised Corporation Code, and specifically we'll take up the topic of dissolution. So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. A like on this video or any of my other videos would also be greatly appreciated. So what is dissolution? Dissolution is simply the extinguishment or the death of the franchise of a corporation and the termination of its existence. Remember that even though it is the incorporators that set up a corporation cannot exist without a special grant by the state, either through a general law such as the Revised Corporation Code or a special law. I discussed this in my previous videos. Therefore, what the law itself has granted, the law may take away, and a corporation may come to an end and its life extinguished only by the act or with the consent of the state by which it was established. Now, dissolution may be a de jure dissolution or a dissolution in law brought on by the act of or with the consent of the sovereign power, meaning the state, which may be by judicial sentence or expiration of the corporate life. Dissolution may also be a de facto dissolution, which takes place in substance and in fact, where the corporation, by reason of insolvency, cessation of business, or otherwise, suspends all of its operations and goes into liquidation while still retaining its primary franchise to be a corporation. Generally, there are two steps in corporate dissolution. First, the termination of the corporate existence insofar as the right to go on doing ordinary business is concerned. Meaning when dissolution happens, the corporation should no longer continue operating in the normal course of business because it's already dissolved. But take note of the second step, which is the winding up of affairs or liquidation, in which case the debts of the corporation are paid to creditors and its assets will be distributed to the stockholders and other persons in interest. This is important because it is only after the winding up or liquidation phase is completed that the corporate existence will be terminated for all purposes. In other words, during the first phase of dissolution, where the corporation can no longer do ordinary business, the corporation will still exist, but only to wind up its affairs. After the affairs have been fully wound up, that is when the corporation will cease to exist. That's when it dies. Okay? Of course, even after the formal dissolution of a corporation, any of its stockholders may form another corporation which will engage in the same line of business. And this may also be done during the liquidation or winding up period. There is nothing that will prevent the stockholders from making another corporation, except if there are stipulations in a contract prohibiting them from competing, like non-compete clauses, etc. But under the law, there is nothing that will prevent them from making another corporation. Okay? Now, remember, the default term of existence for a corporation is that it can exist perpetually, unless, of course, it is expressly stated in the articles that the corporation will only exist for a limited term. I also discussed this previously, okay? But despite this perpetual existence, the law allows for the dissolution of a corporation through two methods. Okay? We have the voluntary dissolution and we have the involuntary dissolution. Let's first talk about the voluntary dissolution. Under voluntary dissolution, there are two ways in general, how to dissolve a corporation voluntarily. This is by filing an application for dissolution with the SEC and or by amending the Articles of Incorporation to shorten the corporate term. Okay, let's talk about the first way, which is the filing of an application for dissolution with the SEC. Under this method, no, there are also two situations rather, no. First is where no creditors are affected, and second is where creditors are affected. In case there are no creditors that will be affected, all that is needed is for the board to arrive at a majority vote calling for dissolution, and this majority vote of the board must be ratified by at least majority of the outstanding capital stock or members. Okay, of course that vote ratifying the majority vote of the board must be arrived at during a meeting called for the purpose, with notice that is given to the stockholders at least 20 days prior to the meeting. That same notice must also be published once in a newspaper where the principal office of the corporation is located, or if there is none, in a newspaper of general circulation. Now, publication of that notice is necessary, no, for the protection of creditors. So after that majority vote of the board is ratified, then a verified request for dissolution will now be filed by the corporation with the SEC. Okay, you file a verified request for dissolution. Now, within 15 days from the receipt of the verified request for dissolution, and in the absence of any withdrawal within the same period of 15 days, as stated in Section 137, then the SEC will now approve the request, and the SEC will also issue the certificate of dissolution, upon which the dissolution shall take effect. Take note that the dissolution takes effect upon the issuance of the certificate of dissolution. Same with bringing a corporation into life. A corporation only comes into existence upon the issuance of the certificate of incorporation. A corporation dies upon the issuance of the certificate of dissolution in this case. Okay? Now, what about the situation where creditors are affected? Then, unlike earlier, which involved a verified request for dissolution, here, what should be filed is a verified petition for dissolution. Okay? Since it's verified, it should be signed by majority of the board and verified by the president or secretary and ratified by at least 2/3 of the outstanding capital stock or the members of the corporation. Okay, take note of the difference, no? Where no creditors are affected, the ratificatory vote is majority of the outstanding capital stock or members. But where creditors are affected, the ratificatory vote is 2/3 of the outstanding capital stock or members. Okay? Now here, the SEC will now issue an order, okay, which should be published once a week for 3 consecutive weeks in a newspaper of general circulation and posted for 3 consecutive weeks in 3 public places in the municipality or city of the principal office of the corporation. And what's the purpose of that order and the publication of the order? It's to allow for objections to be filed to the dissolution. Now, if there are people who want to give their objections to the dissolution, these objections must be given not less than 30 days nor more than 60 days from the time the order was issued by the SEC. Okay? After 5 days from the time to file objections has expired, okay, the SEC will now hear the petition and it will decide on any issue if there are objections. So a hearing is required. If no objections are sufficient and the material allegations of the petition are true, then the SEC will now dissolve the corporation and direct the disposition of the corporation's assets, and may even appoint a receiver to collect the assets and pay the debts of the corporation. Now, the dissolution will take effect only upon the issuance of the SEC of a certificate of dissolution. Okay? Now, let's go to the other way of voluntarily dissolving the corporation, which is by amending the articles to shorten the corporate term. Okay? So we just follow the same procedure to amend the articles which I discussed in a previous video. So you just have to submit the amended articles to the SEC. Okay, you underline the portion which shortens the corporate term, and the SEC will now receive that, no? And in that case, the dissolution will automatically take effect on the day following the last day of the corporate term, without need of the issuance by the SEC of a certificate of dissolution. Okay? So dissolution in case of shortening of corporate term is automatic. Okay? The SEC does not have to issue a certificate of dissolution anymore. Of course, take note that this does not apply to the other requirements like for the LGU, for the SSS, etc. Okay? I'm just talking about requirements with SEC. Okay? Now let's talk about involuntary dissolution. So there are several ways by which a corporation may be dissolved involuntarily. But simply put, no, the corporation is dissolved practically against its own will. No, it was not the one who initiated the dissolution. So first case, no, in case the corporation was set up with a limited term, then the corporation will be dissolved by expiration of that term. No, if that day arrives, the corporation will be deemed dissolved as of the day following the last day of its existence. Another instance of involuntary dissolution would be legislative dissolution, no, by the legislature. Okay? Especially with regard to public utility franchises when the common good so requires. Of course, since the franchise is a privilege granted by Congress, Congress can take that privilege away. Okay? Another instance of involuntary dissolution would be a quo warranto suit against a de facto corporation, which is the proper remedy. I talked about this de facto corporations in a previous episode. Another case for involuntary dissolution, no, would be where minority stockholders file a suit for dissolution on justifiable grounds, especially under Section 104, in case the directors or officers of the corporation had committed illegal, fraudulent, dishonest, oppressive, or unfairly prejudicial acts against the corporation or the stockholders, or when corporate assets are being misapplied or wasted. Now, under Section 138, dissolution may also be by order of the SEC, either motu proprio, meaning on its own initiative, or upon verified complaint. Someone complained, no? And these are the grounds for the SEC to dissolve a corporation. First, non-use of corporate charter. And I talked about this in a previous episode, no? Remember that under Section 21, if a corporation does not formally organize and commence its business within 5 years from the date of its incorporation, then its certificate of incorporation shall be deemed revoked as of the day following the end of the 5-year period. In this case, the dissolution is not automatic. It's not automatic. The corporation continues to exist until the SEC orders its dissolution after notice and hearing. Take note that in case the components of the corporation attempt to complete the organization after such time, that is wholly ineffective and will not even give the corporation the status of a de facto corporation. Okay? That said, there will still be no automatic dissolution until the dissolution has been lawfully declared by the SEC after notice and hearing. Okay? But if the SEC so declares a dissolution, the effect of such declaration will go back to the time that the corporation was deemed dissolved. Okay? Next ground where the SEC can issue an order dissolving the corporation would be for continuous inoperation of a corporation, which is also under Section 21. So if a corporation has commenced its business, but subsequently becomes inoperative for a period of at least 5 consecutive years, the SEC may, after due notice and hearing, place the corporation under delinquent status. Hindi pa kagad dissolved, delinquent status muna. Okay? A delinquent corporation shall have a period of 2 years to resume operations and comply with all the requirements that the SEC may prescribe. And upon compliance, the SEC will now issue an order lifting the delinquent status. But failure to comply with the requirements and to resume operations within the period will cause the revocation of the corporation's certificate of incorporation, which results in dissolution. Next ground. Upon receipt of a lawful court order, meaning there is a case before the court and the court has found that the corporation should be dissolved. Okay? Also, upon finding by final judgment, that the corporation procured its incorporation through fraud. Okay? Their incorporation was fraudulent. Okay? Final judgment ang kailangan. Next ground, also, final judgment. Upon finding by final judgment that the corporation was created for the purpose of committing, concealing, or aiding the commission of securities violation, smuggling, tax evasion, money laundering, or graft and corrupt practices, or final judgment finding that the corporation committed or aided in the commission of securities violations, smuggling, tax evasion, and the stockholders knew of the same. Okay? And third, by final judgment also, repeatedly and knowingly tolerated the commission of graft and corrupt practices or other fraudulent or illegal acts by its directors, trustees, officers, or employees. Now, don't worry, those are all codal. That list is codal. You can just find it in the law. Okay? But take note that the SEC and the courts may order the dissolution of the corporation on the grounds that I just mentioned. Okay? So, in the last 3 cases I mentioned, involving the final judgment, the assets of the corporation after payment of its liabilities, the assets shall, upon petition of the SEC with the appropriate court, the assets shall be forfeited in favor of the government, without prejudice, of course, to the rights of innocent stockholders and employees for services rendered and to the application of other penalties or sanctions under the law. Also, take note that under Section 158, the SEC may order dissolution of the corporation and forfeiture of its assets after notice and hearing in case of a finding that the corporation has violated the Revised Corporation Code or any of the SEC's orders. Okay? So, now let's talk about the effects of dissolution. First, legal title to the corporate properties is transferred to the stockholders who now become the co-owners. Okay? Second, the corporation ceases as a body corporate to continue the business for which it was established. Okay? It ceases as a body corporate to continue it can no longer continue its business, in other words. Okay? Third, the corporation, however, will still continue as a body corporate for 3 years for the purposes of winding up or liquidation. And finally, upon expiration of the 3-year winding up period, then the corporation now ceases to exist for all intents and purposes. Take note that despite dissolution, again, the stockholders are not prevented from conveying their respective shareholdings toward the creation of a new corporation to continue the business of the old. Okay, they can reincorporate by filing new articles and bylaws. Okay, with that, that's dissolution. Now we can talk about liquidation. Liquidation is also known as the winding up of affairs. It's the same. Liquidation, winding up, okay? And liquidation is the process by which all the assets of the corporation are converted into liquid assets or cash in order to facilitate payment of obligations to creditors, and the remaining balance, if there is any, you give that to or distribute that to the stockholders or members. Take note that the liquidation I will be talking about here is the liquidation of a solvent corporation in general, or one that is not in distress, no? Or it's not insolvent, okay? Because that is covered under the Financial Rehabilitation and Insolvency Act, or FRIA, okay? Which I may discuss in a future episode. Let's see, okay? Now, I reiterate and emphasize that a dissolved corporation continues to be a body corporate for 3 years from the time it is dissolved for the purpose of liquidation or winding up of its affairs. Take note that under the case of Helano versus CA, claims which are brought within or even before the 3-year period for liquidation may be prosecuted even beyond said period, let's say for 10 years, no? As long as the claim is brought within the 3-year period for liquidation or before that. Okay? If the 3-year period has ended, anytime after that, you cannot bring claims anymore. It has to have been brought during the life of the corporation or after dissolution, during the winding up. Okay? Anything after that, no more. If it has been brought during the life of the corporation or it has been brought during the winding up period, it may continue even past the 3 years. Okay? But as long as the 3 years has ended and you did not file any claim, then it cannot continue. It cannot be recognized. No, you cannot prosecute that. It's unenforceable. In other words, the termination of the life of the juridical entity does not by itself cause the extinction or diminution of the rights and liabilities of such entity, nor those of its owners and creditors. This is supported by Section 184, which says that no right or remedy in favor of or against any corporation, its stockholders, members, directors, trustees, or officers, nor any liability incurred by them, shall be removed or impaired either by the subsequent dissolution of said corporation or by any subsequent amendment or repeal of the revised corporation code. In other words, the corporation or its stockholders, no, or its directors or members, they cannot evade liability by the mere expedient of dissolving the corporation. Okay? That's obvious bad faith. Okay? So, that's contained in Section 184. Now, let's go to the methods of corporate liquidation. We have 3, no? We have liquidation by the corporation itself under Section 139, liquidation by a duly appointed receiver under Section 135, and liquidation by trustees to whom the board of directors or trustees had conveyed the corporate assets. Again, this is only under the revised corporation code, and this is different from liquidation under the FRIA, no, the Financial Rehabilitation and Insolvency Act. Okay? So for the first method, the corporation through its board and its officers, they take charge of the winding up operations. Section 139 grants the corporation a period of 3 years after dissolution within which to wind up its affairs. Any claims by or against the corporation which are not presented and settled within that period become unenforceable. Why? Why are they unenforceable? Because of course there is no longer any corporate entity against which they may be enforced. Wala na yung corporation, kanino ka mag-enforce? Patay na. Okay? However, take note of the case of Republic versus Marsman, which says that there is nothing in the law that prevents an action for the recovery of debts of the corporation against the liquidator after the lapse of the 3-year winding up period. Take note of that. Okay? Now, for liquidation by a receiver, no, under the second method, remember in my discussion earlier that in case the SEC orders the dissolution of the corporation under Section 135, the SEC may also appoint a receiver, okay, taga-receive, no, to collect the corporation's assets and pay the debts of the corporation. Courts may also appoint receivers in the proper cases, not just the SEC. And such appointment of a receiver is discretionary. Okay, the SEC or the courts exercise discretion on whether they will appoint a receiver. Because a receiver will only be appointed if there is a showing that a receiver is necessary to protect and preserve the properties of the corporation for the use and benefit of its creditors and other interested parties. In case the directors are guilty of a breach of trust, the minority stockholders may also ask for receivership. Okay, and that's the doctrine in the case of Chase versus Court of First Instance. Okay? Now, unless there is a specific limit to the duration of receivership, then the receivership will exist indefinitely until the affairs of the dissolved corporation are completely settled and liquidated. While under receivership, claims can be presented and allowed as long as they are not barred by prescription, okay, or the statute of limitations. So in this case, the 3-year period does not apply, okay, and that's the pronouncement in the case of Summers versus Valencia. Now, liquidation may also be placed in the hands of a trustee or assignee under the third method, no? The liquidation may be placed in the hands of a trustee or assignee to whom the corporate assets are conveyed. Okay? The effect of the conveyance is to make the trustee the legal owner, okay, of the property, subject to the beneficial interest of the creditors, stockholders, members, and other persons of interest. Okay? As such, the trustee may sue and be sued as such in all matters connected with the liquidation. Take note, under the same case of Helano versus CA, the word trustee, okay, the word trustee is understood in its general concept, which may include the counsel or the lawyer entrusted with the prosecution of the suit filed by the corporation. As I mentioned earlier, the trustee may commence a suit which can proceed to final judgment even beyond the 3-year period, especially where it was the corporation itself that commenced the suit during its existence. Okay, and the trustee, by legal fiction, he merely continues the legal personality of the dissolved corporation. Okay, parang sub, okay, parang sub lang, substitute. Okay. The purpose of the transfer of the assets of the corporation to a trustee upon the dissolution of the corporation is for the protection of the creditors and stockholders of the corporation. Finally, as to distribution of assets, the last paragraph of Section 139 states that except by decrease of capital stock and as otherwise allowed by the Revised Corporation Code, no corporation shall distribute any of its assets or property except upon lawful dissolution and after payment of all its debts and liabilities. So this is consistent with the trust fund doctrine, which I have discussed in several episodes previously. Okay, the trust fund considers the subscribed capital as a trust fund for the payment of debts of the corporation to which the creditors may look to for satisfaction of their debts, the debts owed to them. No? Until the corporation is liquidated, no part of the subscribed capital may be returned or released to the stockholders without violating the trust fund doctrine, except of course in the case of redeemable shares. Now, how will the assets be distributed? If the assets are enough to cover all the debts, then there is no problem. Okay? Especially when it comes to priority in payment. No, you just distribute them. Okay? According to what is owed to each. Priority in payment is only important when the assets are insufficient. So generally, this is the order that will be followed, which of course is subject to the rules of FRIA, now the Financial Rehabilitation and Insolvency Act, no? And the rules on concurrence and preference of credit, either under the Civil Code or the Personal Property Security Act, as the case may be. If the corporation is insolvent, then the creditors are entitled to have all its assets distributed first among them, of course, according to their rights and priorities, no? There may be encumbrances, junior encumbrances, etc., no? This is consistent, of course, with the trust fund doctrine because you have to satisfy the debts owing to the corporate creditors. Next, second, no, loans which have been made by stockholders or members or directors or trustees to the corporation. That makes them creditors, okay? So you have to pay those next. Third, the remaining assets will now be distributed among the stockholders or members in proportion to their shareholdings or interest, no? In the absence, of course, of any provision to the contrary, such as those contained in preferred shares, no? Remember, in my discussion on preferred shares, they may be preference as to assets in case of dissolution. So, of course, you have to follow that. And finally, under Section 139, any asset which is distributable to any creditor or stockholder or member who is unknown or cannot be found will be escheated in favor of the national government. Okay, so the government gets that. Okay, so that's it for my discussion on dissolution. I hope you may have picked up a thing or two, and I hope to see you next time, guys. Okay, see you soon. Bye.